Right, today I'm going to take a little bit of a different spin and look back in time. And we're looking at the state of New South Wales versus Kisconsin 2021. I'm just going to read the text. We'll comment as we go. It's going to be made up of a lot of different videos, this, because it's going to take some time to go through. I guess we attention this to the Attorney General, both of New South Wales and of Australia, and likely all the other Attorney Generals of state and territory, because this relates to your little knock on the door from the United Nations. So, Supreme Court case, New South Wales, medium neutral citation, State of New South Wales versus Kisconsin, preliminary, 2021, NSWSC 915. Hearing dates, 21st of July 2021, date of orders, 27th of July 2021, decision date, 27th of July 2021. So we can see this case took one sitting in a courtroom, jurisdiction in common law, the Court of Common Law of New South Wales, before Justice Lonergan. Justice Julia Lonergan has been sitting in this position at the Supreme Court for a number of years. Decision. Amended summons dismissed. Number 2. Plaintiff to pay the defendant's costs. Catch words: high risk offenders, preliminary hearing, whether interim supervision order should be made, whether matters alleged would, if proved, justify an ESO, whether offender poses an unacceptable risk of committing a serious terrorism offence. Application refused. Legislation cited: Criminal Code, Commonwealth, so it'd be the Criminal Code 1995. Firearms Act 1996, New South Wales. Terrorism, High Risk Offenders Act 2017, New South Wales. Cases cited: Minister for Home Affairs versus Ben Breaker, 2021, 388, ALR1, 2021, HCA 4. State of New South Wales versus Fired, preliminary, 2020, New South Wales, SC 1681. Category: Principal Judgment. Parties: State of New South Wales, the plaintiff, and Kisconsin, the defendant. Representation: Counsel: J. Emmett, SC / T. Epstein, plaintiff; M. Johnston, SC / E.S. Kirkyasharian / S.J. Young, defendant. Solicitors: Crown Solicitor's Office, New South Wales, plaintiff; Ryan Payton Lee, defendant. File numbers: 2021 /002 01054. Publication restriction: nil. Choose an item. So we've laid out a court matter that has occurred last year. We can see that the matters have been dismissed. We can see that applications were refused. And we can also see that orders weren't justifiable. This is just in the leading catchwords that will appear throughout the case. Right, so as we carry on, this case has a lot of backstory, which we'll fill in as we go. This starts to now look into the case. Choose an item. Judgment. 1. The plaintiff, the State of New South Wales, brings proceedings against K, the defendant, pursuant to the High Risk Offenders Act 2017 New South Wales, the Act, in inverted commas, for an interim supervision order, an ISO, under S27 of the Act for 28 days, with a view to obtaining an extended supervision order for 3 years on specific conditions. Ancillary orders are sought for the appointment of 2 psychiatrists or psychologists under Section 24I of the Act, and that the defendant be directed to comply with a series of conditions, 55 in number, during the period of the ISO. These 55 conditions aren't listed in the report here, but they obviously can't use a phone, can't use the internet, can't use this, have to wear the right coloured undies, have to use the right type of toilet paper. Like that, they would be pretty stringent, and given that they would be wanted to be followed for 3 years, the defendant opposes the imposition of an ISO or ESO. So we have a plaintiff claim, pretty seriously strong one, and the defendant saying no, that's not justifiable. The summons seeking these orders was dated the 12th of July 2021 and was filed on the 13th of July 2021 in the 10 days prior to this court. An amended summons was filed in the court with leave on the 21st of July 2021, which would be this date. The defendant is due for release at midnight on the 29th of July 2021. So the police have attempted at the very last days of a sentence to jump in on the gun to further impact the life of someone over some very spurious and stupid claims that we're about to go through. This all started in a very largely disrespectful way, with a total ignorance of the facts that are on the table, and it just squarely belongs in the Attorney General of New South Wales' hands when we look at what we're about to go through. The legislation. 5. The requirements for making an ESO are set out in SS 20 and 21 of the Act. 20. Supreme Court may make extended supervision orders against eligible offenders if unacceptable risk. The Supreme Court may make an order for the supervision in the community of an eligible offender called an extended supervision order if A. The offender is in custody and under supervision, or was in custody or under supervision at the time the original application for the order was filed. You can see why the police have attempted to jump the gun, so to speak. I. While serving a sentence of imprisonment for New South Wales indictable offence, or under an existing interim supervision order, extended supervision order, interim detention order, or continuing detention order. We can see through the toy gun that the police have again jumped the gun. B. An application for the order is made in accordance with this part, and C. The Supreme Court is satisfied that the offender is in any of the following: a convicted New South Wales terrorist offender, a convicted New South Wales underlying terrorism offender, a convicted New South Wales terrorism activity offender, and D. The Supreme Court is satisfied to a high degree of probability that the offender poses an unacceptable risk of committing serious terrorism offence if not kept under supervision under the order. So this already puts the police's mindset in a certain framework wherein they have an objective to attack. But they've jumped in at the last minute to attempt to impact someone with some seriously harsh conditions and attempt to put that person through psychiatric assessment. And this is a large key point of where we go down this little rabbit hole that we're about to venture into.